Thank you. Good morning, Your Excellency. I would like to begin by reading out a statement, please. This hearing is in the matter CFI 34/2021 before His Excellency Justice Nasser Al-Nasser and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by ARA Group advocates and legal consultants. Lead counsel is Asha Bijoy. The defendant is represented by Emirates Legal. Lead counsel is Sayed Mujtaba. Thank you.
Thank you. The claimant may start, please.
Much obliged, Your Honor. Your Honor, I would like to take you through a brief facts leading to the present claim. And it goes like as follows. The claimant in this case is AL-EATESAM Modern Marketing Company Limited. The claimant is a company incorporated in the Kingdom of Saudi Arabia. The claimant is into the business of providing security systems, products, software solutions, and consultancy services. The defendant is Seed MENA Businessmen Services Limited LLC. The defendant is a company incorporated in the UAE. The defendant, amongst other things, assists foreign businesses to establish a business presence in the UAE and help them to expand their business within UAE. It is a claimant's case that on or about July 2018, the defendant approached the claimant with a proposal to expand and establish their business within the UAE. With that objective, the parties started discussing with each other, which ultimately led to the signing of an MOU, followed by a set of definite agreements. The important point to be noted here is that these agreements were executed on the understanding that the defendant would act as a local sponsor and a strategic partner to assist the claimant to establish and grow its business within the UAE. Accordingly, as per the cooperation agreement, which is one of the agreements that were signed by the parties, the claimant agreed to make an annual fee of 1.2 million dirhams, which was agreed to be paid in 3 installments, plus another 80,000 dirhams for the PRO and other expenses for setting up an entity which would be used to promote and market and launch the products, to sell the products within UAE. The claimant also, in the agreements, agreed to share a percentage of the gross revenue that were generated through the introductions made by the defendant. Last but not least, the important point to be noted here is that as per the agreements, both parties have agreed to a set target of 30 million dirhams. Thus, as per the contract, the claimant made payment of the first 2 installments, equivalent to dirhams 700,000 plus VAT, and an additional sum of 80,000 towards other expenses. And the claimants were waiting for the defendants to perform their part of the obligations. However, it is a claimant's position that even after receiving the payments, the second installment, the defendant has failed to perform its obligations under the various contracts. According to the claimant, the very purpose of the collaboration was to achieve the sale target of 30 million. However, the defendant had failed to achieve or make any successful introductions, and as such, the defendant had failed to honor its obligations as per the contract, and it did not help the claimant to generate any business whatsoever. Therefore, the claimant, through this case, approaches this honorable court seeking a refund of all the payments that they have made under the various contracts, plus other expenses for initiating this case. On the contrary, it is the defendant's position that the claimant does not have a cause of action. According to the defendant, they have performed its obligations prescribed under the agreements, and as such, there's no breach of contractual or other legal obligation. payments made by the defendants, according to them, are not contingent upon any target. And it is also their position that there is no specific clause within the contract that permits the claimant to seek a refund. The defendant also makes a counterclaim against the claimant on the basis that their financial obligation under the cooperation agreement has not been fully performed, and there are payments due under the cooperation agreement for which they are making a counterclaim against the claimant. So this is basically an overview of the case. So it's about payments made and seeking a refund. And as for the defendant, they are making a counterclaim for the balance payment due under the cooperation agreement. As for the CMC, this is, the case memorandum has already been agreed upon, and we have a set of agreed issues. The case information sheet is also mostly agreed by both parties, except for a minor change which just came to our attention, that the claimants, as per their case information sheet, they have mentioned that they would be filing the expert report by 14th of September. However, the claimants do not wish to go for an expert witness. Other than that, there are no other changes in the case information sheet, and the claimants fully agree with, and both parties agree on the timelines, the case memorandum, and the list of issues. And as such, the claimants do not foresee or have any specific concerns to be addressed within this case management conference. That's all, Your Honor.
Thank you. The timetable was agreed on, yeah?
Yes, Your Honor.
The only...
Your Honor.
Yes.
With your permission, will it be possible for me to point out a few issues in relation to the submissions made by the claimant?
Yes.
Your Honor, the short point for consideration in the instant case is whether the target of AED 30 million is a target that needs to be achieved by both parties. And the only way, Your Honor, this could be understood more clearly is from the documents itself. I understand that this is only a case management conference, but since we have more or less agreed to the framing of the issues, but I want to bring to the attention of the court certain critical facts that must be taken note of by this honorable court. Your Honor, if you look into the cooperation agreement, and cooperation agreement...
I will not discuss the merits of the case. My role here is just for case management purposes. So it doesn't...
Your Honor, I would not take you through the merits at all.
Me looking at different contracts which relate to the merits of the case, I will not be deciding this claim anyways.
Absolutely, Your Honor. Your Honor, the only idea was because Article 8 through 8.3 of the cooperation agreement is very relevant for framing of the issue. And now, the main issue in this case is whether the target of 30 million, which is contained in the MOU, and then referred to in the cooperation agreement, but not as that the non-achievement of this target would lead to refund of the entire sums of money. So we have agreed on the issues, but there are a couple of important points in the case management sheet, which this honorable court must take note of, where there are some discrepancies in relation to what has been submitted by the claimant. And I want to bring at least those discrepancies to the attention of this honorable court. Your Honor, this case management information sheet is at A26 hearing bundle. If this honorable court may, page A26, A alpha 26, okay. Case line. Okay. Your Honor, in this case information sheet, I want to bring two important points. to the attention of this Honorable Court. First is that at paragraph 3, they have stated that they will provide us the standard production of documents that we will request by 15/11/2021, and we take note of that. But then at paragraph 5, they have stated, have the parties discussed standard production of documents? In particular, have the parties discussed the production of electronic documents? If so, please provide a material areas of agreement and disagreement. So, Your Honor, in this particular case, we are going to we have not made a request upon them as yet about, we have made a request generally in our reply, but we have not made a formal request to them about what documents we need and what information exactly we require. But we take note of so there has been parties have not agreed. If they have agreed to provide us that information, they need to see what information we specifically require. So we will be them this information that we require in a course of 7 days from now. So if this could be taken note of by this Honorable Court. So this is point number 1, Your Honor. Point number 2 is at paragraph 7, which is on page 827 of the CMC bundle. The question says, have the parties discussed likely or potential requests for production of specific documents? In particular, have the parties discussed the request to produce electronic documents? If so, please provide it. So we have not so far discussed the potential request for production of documents. We are going to make a request in the next 7 days. So this is the point that I wish to bring to the attention of the Honorable Court. And the other point is at page 828 of the case management information sheet, which is at paragraph 16. Paragraph 16 reads as, is there any way in which the court can assist the parties to resolve their dispute or particular issues in it without the need for a trial or a full trial? So, Your Honor, please take note that this has been answered in the affirmative. So they have stated yes. And I want to take you to this next paragraph, which says, might some form of alternate dispute resolution procedure assist to resolve the dispute or particular issues in it? They have said yes again. And at 17b, the question is, has the question at A been considered between the client and the legal representatives, including those that have appeared at trial? Meaning, have they discussed this issue with us that they want to abandon their case, which has been filed before the DIFC courts under Part 7, and they want to instead choose an alternate dispute resolution, and to which they have said yes, and I'm afraid it is not correct. We never discussed and we never agreed. And Your Honor, one last point is at page 829, 17, paragraph 17F. Are any other special directions needed to allow for alternate dispute resolution? And they have said yes. And they have not. The point that I want to bring to the attention of this Honorable Court is at least this Honorable Court must ask the opposite party, what does it mean after filing a claim under Part 7? After we have filed our statement of defense. They have filed a reply to the statement of defense. We have found our counterclaim. They have filed a reply to our counterclaim. At this stage of the proceedings, where we are before the court, for the purposes of discussing the evidence at trial and how the proceedings will conclude henceforth, it seems that the opposite party feels uncomfortable with the Part 7 claim and instead seems to propose an alternate dispute resolution mechanism. This is very strange, Your Honor. And if they are proposing an alternate dispute resolution mechanism, then they must also tell the court under 17F about what directions are needed from this Honorable Court to allow for an alternate dispute resolution mechanism. And a question also was asked by them, have you discussed this issue of alternate dispute resolution mechanism with the counsel for the opposite party? And they have written yes. I'm afraid, Your Honor, these are discrepancies that I see that need to be addressed.
What's the claimant's view on this?
Thank you, Your Honor. I have been taking instructions from my Part 1 lawyers, and I was told that at this moment in time, they do not wish to seek any specific directions from the court in terms of alternative dispute resolution. However, they would be open to an idea for an amicable resolution if that happens before the matter proceeds to the next stage of document production. So with that objective, we do not wish to have any change in the proceeding as such. However, we would in the meanwhile take an initiative to approach the defendants with settlement offer. If that materializes, and it is with that intention that we have mentioned S for questions 16 and 17. And this is the instruction that I have from my Part 1 lawyers.
So you didn't have discussions yet, but you're open for amicable discussions.
Exactly, Your Honor.
Thank you.
Your Honor, I have two objections to that. First objection is, in fact, I should have moved an immediate judgment application, but I don't want to take you through the merits of this case. Second point is paragraph 16 and 17 is an amicable settlement can take place at any time during the proceedings. But paragraph 16 and 17 have asked for a very specific information, which is whether they want an alternate dispute resolution. The legal effect, Your Honor, of the statement which the claimant has made is that now it can be interpreted, Your Honor, only in one way. They filed a Part 7 claim. They want the case to go to trial. And thereafter, they have stated that we want to take this case out of that trial. Now, Your Honor, clearly, we have incurred costs. We have spent an enormous amount of time.
This case
sorry,
will
Your Honor?
proceed this case will proceed to trial.
Yes, Your Honor.
So I don't, as the claimant mentioned, they're not looking for a direction from the courts for alternative dispute resolution. However, they are open throughout the proceeding for an amicable settlement. But as of today, I guess that this will proceed to the date of the trial. So we have to go through the case management. If the parties both agree to the case management order, then this is the purpose of today's hearing.
Yes, Your Honor.
As the claimant mentioned, they are open for amicable settlement, but not under the supervision or direction of the courts. If it would happen, it would happen on without the court's interference. Although in the information sheet, answering those questions should have been no, not yet. But this doesn't change anyways how we will proceed today.
We apologize for the error, Your Honor. We will correct the case management information sheet to remove the S, and we will insert a no for the direction question. And it is our interest and our request that the case should proceed to the next step.
Yes, I think we should be discussing the case management order. From what I saw that I saw two documents of case management order, two drafts, which are identical. So I believe the parties agreed on the list of issues.
Yes, Your Honor.
Even the issue the defendant just mentioned in relation to Article 8.3 of the Cooperation Agreement is part of the list of issues. So this would be discussed at trial. And in relation to production of documents, the parties will have the opportunity to produce standard production on 15 November, and then any party wish for any party have the right to then request for certain or specific documents.
May I make a submission?
Yes.
Your Honor, with your permission, I wanted to make a small submission here, which is that we would provide documents for certain information which we do not have, which is in the exclusive possession of the claimants.
Can you repeat, please, what you said? Because I think the line is not the line was disconnected.
I apologize, Your Honor. So, Your Honor, I want to make a request because our counterclaim is based on two important things. As the counsel for the claimant read out to you that there is a revenue sharing agreement, and pursuant to revenue sharing agreement, 5% of whatever business they do in this country, that revenue has to be shared with us. Now, in their letter to us, they have admitted that they have done business with 5 important companies in the UAE. We have not been provided with the details of the business that they have carried out, and they have admitted, I can show to the court a paper, a letter from them, where they have admitted that they have generated business successfully from those companies that were introduced by the defendant. So, Your Honor, we want from them all the details of them and how much money they have made from them, so that we are entitled to 5% of our share. And accordingly, once that information has been made available to us, we should be given the chance to make an amendment to our include the correct amount, because at this moment we only know that they carried out the business, but we do not know how much money was made in this regard. So we would be grateful if this honorable court will give us 7 days time to give them the specific details of this request, and thereafter they have also given their date itself that they will provide these documents by a specified date at paragraph 3 of this their case information sheet. So we are okay with the date. But is it possible, Your Honor, to give us 7 days within which we can make this request? And if this could also form part of the order, CMC order, that will be highly appreciated.
So you want this to be part of the CMC order?
Yes, Your Honor. And in fact, Your Honor, my colleague has pointed out to me that we have already made this request. And this request is a of the hearing bundle, which is the draft order. At C4, we have already made a request that the scan of documents shall be made by each party no later than this. The party shall file and serve a request to produce, if any, by no later than 4 p.m. on 14th December. Objections to the request to produce, if any, shall be filed within 7 days. So, Your Honor, I was only requesting that the date that we have mentioned in the draft order is 14th of December. We would be very grateful if this date could be brought earlier to, so that we have an opportunity to submit our production of documents at an earlier date. So this is the only thing, only small change. Everything has been agreed, Your Honor. There is nothing.
Which date you're looking at?
Your Honor, today is 5th of October. I was thinking if we could be allowed until 15th of October.
Or a request to produce.
Sorry, 17th of October. 17th is the next working day. 15th is a Friday.
And when the standard production should take place?
It should take place by November, within 1 month, 17th of November.
And what's the claimant's view on this?
Yes, we are absolutely fine with the defendants making requests for production of documents, and we would be complying with the document production request as per the RTC provisions, the relevant provisions. So we are comfortable, we are happy to agree to 17th of October for the production request, and for the standard production to be scheduled for the 17th of November.
Okay,
and
then
Your Honor,
can you amend the draft order and send it to the court?
Yes, Your Honor.
and consider also where there will be objections for the courts to decide also.
Yes, Your Honor.
Much obliged, Your Honor.
Yeah. Anything else?
I think, Your Honor, we are okay with most of the issues.
Yeah. Anything from the claimant?
That's all, Your Honor.
Okay, then I will be waiting for your amended draft order, so the court can issue the CMC order. Yeah.
Thank you,
Grateful,
Your
Your
Honor.
Honor.
Thank you both parties.
Thank you.
Thank you.
Thank you.